Check, check one, check two. Testing one, testing two. Check one, check two, testing one, testing two.
Check 1, 2, 3, testing 1, 2. Check 1, 2. Check 1, 2, testing 1, 2. Check 1, check 1, 2. Check 1, 2, testing 1, 2.
evening, distinguished guests, respected arbitrators, competitors, alumni, other invitees, and a very warm welcome to all of you. We gather here today to mark the grand finale of an exceptional journey, the 8th H.V. Pereira QC Memorial International Moot, Sri Lanka's first and premier international commercial arbitration moot competition, hosted with pride and distinction by the Moot Society of Sri Lanka Law College. Ladies and gentlemen, since its inception in 2018, the Victors Moot has provided a platform for law students worldwide to exhibit their advocacy talents. Named in commemoration of Dr. Herbert Victor Pereira, Queen's Counsel, a distinguished and renowned personality in the field of law in Sri Lanka, Victors Moot has over the years served its purpose of elevating the legal knowledge and the knowledge on commercial arbitration in Sri Lanka and globally. Over the past few days, we have witnessed exceptional performance from teams across the borders who engaged in an intellectual duel of wit, reason, eloquence, and advocacy. Tonight, we come together not just to crown the champions, but to celebrate the spirit of justice, diplomacy, and unity through law. In the time-honored fashion of beginning things in Sri Lanka, let us commence the proceedings with the lighting of the oil lamp. Ladies and gentlemen, this act, to those of who are joining with us online from across the globe, this act is not something that is merely ceremonial. It is deeply symbolic. In the Sri Lankan culture, the oil lamp symbolizes wisdom's enlightenment and the triumph of knowledge over ignorance. As each flame is lit, it reminds us of the path that we are called to follow, the pursuit of truth, fairness, and justice. May I now invite the following dignitaries to light the ceremonial oil lamp. The chief guest of the 8th Victors Moot, the Chief Justice of the Democratic Socialist Republic of Sri Lanka, Her Ladyship Muthu Fernando, President's Counsel. The guest of honor, the Solicitor General of Sri Lanka, Mr. Viraj Dayaratne, President's Counsel. The guest of honor, Dr. Kanagiswaran, President's Counsel. The Principal of Sri Lanka Law College, Mr. Prasantha Laldi Alvis, President's Counsel. The former Principal of Sri Lanka Law College, Mrs. Indira Samarasinghe, President's Counsel. Arbitrator of the finals, Dr. Asanga Gunavansa, President's Counsel. Mr. Upul Jayasurya, President's Counsel. The Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, Attorney at Law. The President of the Moot Society of Sri Lanka Law College, Mr. Tisuru Hettiarachchi, and the Chairperson of the 8th Victors Moot, Mr. Vinura Gamake. Thank you very much. Ladies and gentlemen, I request you to remain standing for the anthem of Sri Lanka Law College. Very much, ladies and gentlemen. You may now take your seats. To formally welcome you to this elegant gathering, I now invite an individual whose leadership continues to inspire excellence across our halls. The principal of Sri Lanka Law College, Mr. Prasanta Laldi Alvis, President's Counsel, a respected senior of the bar, a teacher to many, and an advocate of both tradition and innovation. Over to you, sir.
My task today is to make the welcome address. To go away from the normal norms, I would like to invite my Deputy Principal, Shan Perral, Attorney at Law, President of the Moot Society, Tisuru Hettiarachchi, and the chairperson of this project, Vinura Gamage, to be here, please. The speech that I'm supposed to do is welcome. Without these people, I don't think I am justified standing here on behalf of Sri Lanka Law College. Ladies and gentlemen, today we are here for Magul Gedara of Law College. This is where Law College, Sri Lanka Law College, goes to the world. The entire world looks at us. Entire world is focusing on us. And Sri Lanka Law College is in the limelight. That's the representation we have. This is a project with absolute commitment of these two and the team. And it's a complete sweat and the commitment, effort of this team and the staff and the law college students. In order to be an attorney at law, my lady, you have to have 3 ingredients according to Section 40 of the Judicature Act: competent knowledge, repute, and ability. This project covers all these 3. It gives competent knowledge on a particular subject which is so vital, and that is alternative dispute resolution. And the other one, their ability is manifested, trained, and how they train the first years, how they mold them to take this role which you can see on that side is amazing. So they create reputation, they create ability, and that is exactly what Section 40 is asking us to do. So this project, the Moot project, embodies all these 3 criteria that an attorney at law should possess. The second factor is this so critical that the alternative dispute resolution, I can vouch as a corporate director. I was director Sampath Bank for 9 years, Siyapatha 9 years, now at Asset Line. None of us want to go to courts. We always want to settle matters. That's a fact, sir. Kanagishwaran, sir, that's a fact. When we sit there in the board, though I am a lawyer, we encourage alternative dispute resolution. Because delays in court and other factors makes us ponder and wonder whether going to courts is the best method when you look at the interest of the company that we are directors of. So this is the future, commercial arbitration. And that is exactly we are going in that direction. Our curriculum development committee has gone into this, and they want to make this topic, arbitration and mediation, a permanent, mandatory subject, my lady. Your ladyship will have very soon to consider this proposal of the curriculum development committee. My lady and ladies and gentlemen, our neighboring country, India, launched a very interesting program on the 1st of July, 30 days of mediation, by His Lordship Chief Justice India B.R. Gawai and Supreme Court Judge Suryakant. They are going to concentrate from 1st of July to September, 30 days of concentrated effort on mediation from the Taluka courts, that's the lowest court, to the highest high court. And that is the trend that India is following now. So in that kind of a background, this Moot plays a pivotal role in driving the alternative dispute resolution. That's why it is commendable and of the fact that Sri Lanka Law College is taking this step. Now my task is to welcome the distinguished guests here. We have with us Her Ladyship Murdu Fernando, President's Council, Chief Justice of the Democratic Socialist Republic of Sri Lanka. My lady, your tenure as a member of the Council, and also now as a Chief Justice. We admire you, all of us, students and the staff alike, for your gentle way we handle very empathetic way of handling the students, but in a firm manner. A balance of this was visible during this short span. And we will host you on the 17th. We will keep you, there are certain surprises that you have on the 17th. We will keep those surprises, my lady, for that occasion. We welcome you with warm hearts to this wonderful function. We have Mr. Viraj Jayaratna, President's Council, the Solicitor General of Democratic Socialist Republic of Sri Lanka. With your power, there were so many issues of our property issues. Thank you so much for sorting out those with your leadership. Thank you so much, Solicitor General, sir, for taking that initiative and sorting out these so that we have a clear path on our property issues. We will warmly welcome you as our guest of honor. Mr. Kanageshwaran, sir, President's Council, we always look up to you for leadership, Sri Lanka Law College. And this is very relevant to you. You gave us, Sri Lanka Law College, a moot court. That was the center where these boys and girls were working on from Saturday till this morning. I wish you saw that so that you can be immensely proud what you gave it to us. We are very much glad that you are here with us this evening, and we cherish your name, and we cherish your memory of giving this amazing moot court to the Sri Lanka Law College. Thank you, sir. And we warmly welcome you. Then we have amazing panelists. We have AI and arbitration, very interesting dialogue, moderated by Ms. Tanuki Gunasinghe, who is one of my students, criminal law students, one of the best students. And there will be Professor Chitra Vedikara, our own lecturer, Dr. Sunil Abhiratna, and Mr. Nusri Hussain, again, very close to us, coming all the way from Singapore. I don't think we can call him a Singapore person, but more than that, our own. We welcome you all. And especially the panel. Dr. Asanga Gunawansa, you are in the Board of Studies. The way you handle things was amazing. Guiding stormy things, navigating through us. We cherish those moments, and we are very happy that your commitment to this alternative dispute resolution as a lecturer and as a member of the Board of Studies, your contribution to our institution is immeasurable. We have Mr. Upul Jayasuriya here, who always pushing me to start up a scholarship one. Even today, he was pushing me. Thank you for that support, feel of support, so that we can have a strong scholarship scheme. We have here Ms. Indira Samarasinghe, President's Council, one of our former principals, who guided this Sri Lanka Law College during a turbulent times. And thank you, madam, for being here with us this evening. So, ladies and gentlemen, we have come a long way. When they came up and approached me and Shehan, I never dreamed that this is such a magnitude, because Shehan is handling the moot and the other factors. When you try to tell me that this is an event, I never believed till last Saturday. My lady, I walked out of a gloomy disciplinary inquiry of judging lawyers against indiscipline, and when I walked into their room, I saw the future. My lady, you referred to judiciary as the soldiers of democracy. You can be rest assured that your statement is valid through these boys and girls. They are truly soldiers. They are truly soldiers who will guide the destiny of rule of law in Sri Lanka. Thank you, Mr. President. Thank you, Project Chairman, and the team for making Sri Lanka proud. I respect you for that. And may you have a pleasant evening, and may Sri Lanka Law College be the beacon of legal education who produce the best lawyers in our region. Thank you very much.
Thank you very much, sir, for your inspirational words, as always, sir. Ladies and gentlemen, as we close one chapter tonight, let us now take a glimpse at what got us here. It was a bold vision of a broad stage and a powerful conversation around international arbitration, presenting to you the Victor's Moot, a project of purpose, precision, and promise. May I now direct your attention towards the screen.
Grit,
Diligence.
Excellence.
virtues demanded by the legal profession, virtues that define greatness, virtues that need to be forged in the fires of competition. Established in 2018, the Victor's Moot has been a competition that transcended its peers. This is a tradition, a tribute, a testament to the enduring legacy of one of Sri Lanka's finest legal minds, the late great Herbert Victor Pereira, Queen's Counsel. Organized by the Moot Society of Sri Lanka Law College, the Victor's Moot was envisioned as a platform to train a new generation of legal professionals in the increasingly vital field of arbitration, an area essential to international commerce and the modern practice of law. The 8th Victor's Moot recognizes that the world around us advances at an unprecedented pace, fueled by the rapid progression of technological advancements. We observe that these tech-driven advancements create disputes which manifest with novel dimensions of complexity, challenging even seasoned veterans of law. Acknowledging those realities, this year, the Moot problem presents a dispute in the telecom sector, highlighting complexities of modern M&A transactions and regulatory frameworks. Heard under SIAC rules for the first time in the competition's history, the Moot problem explores the intersection of telecom regulation and private contractual obligations in a cross-border context. Supported by SIAC, Asia's most preferred arbitral institution, we write a new chapter in the Victor's Moot saga this year. The 8th Victor's Moot features the highest number of participating teams, marking a new milestone in the competition's prestigious journey. After months of tireless preparation, rounds of intense legal argument, and days of unwavering determination, we have arrived at the grand finale, the crescendo of excellence in advocacy and legal intellect.
This is where we crown grit.
This is where we crown diligence.
This is where we crown excellence.
Welcome to the closing ceremony of the 8th H.V. Pereira QC Memorial Moot Competition.
From code to case law, the influence of technology is reshaping how we define justice. Tonight's panel will take us to the frontier of this transformation as we head into the panel discussion on artificial intelligence and arbitration. Our moderator for this evening is the ever-eloquent Ms. Tanuki Gunasinghe. Ms. Gunasinghe is a technology lawyer and speaker based in Sri Lanka, with a deep focus on the intersection of law, emerging technologies, and responsible innovation. Ms. Gunasinghe graduated with honors in her Bachelor of Laws program at the University of Colombo and achieved first-class accolades at the bar examination at Sri Lanka Law College. She is currently the only certified AI governance professional from the legal sector in Sri Lanka and the first lawyer to hold an AI strategy role in a Sri Lankan law firm. In this capacity, she leads the integration of AI tools to enhance productivity and ensure ethical compliance use within the legal sector. With that, now I invite Ms. Gunasinghe to hand over today's proceedings.
Good evening, distinguished guests, fellow ADR enthusiasts, and dear students. It is a true honor to welcome you all today to today's panel discussion on AI in arbitration, opportunities, challenges, and the road ahead, proudly hosted by the Moot Society of Sri Lanka Law College. Your presence here reflects the growing interest and commitment to advancing alternative dispute resolution, and I'm excited to share this conversation with such a knowledgeable and passionate audience. We are in the midst of a technological shift that's quietly yet profoundly transforming the practice of dispute resolution. Artificial intelligence, a topic that is close to my heart, once a distant promise, is now influencing how disputes are filed, managed, and resolved, with arbitration sitting right at the intersection of this transformation. Today, we bring together experts who have both academic and practical insights into this evolution. We'll be exploring the growing role of AI in areas such as evidence gathering, online dispute resolution, and how arbitral institutions are evolving in response. Along the way, we will reflect on both the possibilities and the complexities this presents. But first, I have the privilege of introducing the three experts joining me for this important conversation. Professor Chitra Vedikara is a highly respected chartered architect, quantity surveyor, cost engineer, arbitrator, and project manager with over 30 years of international experience. She heads the QServe group, offering expert consultancy in cost management and dispute resolution. Former Dean of the Faculty of Architecture at the University of Moratuwa, she has also held academic positions in Australia. She has held multiple leadership roles, held memberships and fellowships of numerous prestigious professional bodies which are too long for me to list at this point of time. Interestingly, a PhD holder in dispute resolution from Murdoch University, Perth, she brings deep interdisciplinary expertise and leadership knowledge to today's discussion. It is a pleasure and privilege to have you with us today, Professor. Dr. Sunil Aberatne. Dr. Sunil Aberatne is a seasoned legal professional, academic, and commercial arbitrator with experience across civil, commercial, and criminal law. An attorney at law since the year 1986, he holds a PhD in law from the University of Colombo. A passionate educator, he lectures at multiple institutes, including Sri Lanka Law College and the Universities of Colombo and Peradeniya. He has presented over 100 papers at global forums such as Law Asia and IBA, authored works on ICT law, and currently chairs Law Asia's Data Protection, Communication, and Technology Committee. With deep legal insight, academic rigor, and global engagement, he brings immense value to today's discussion. We are grateful to have you as a part of this conversation, Doctor. And last but not least, Mr. Nusri Hussain, a deputy counsel at the Singapore International Arbitration Center, where he manages international arbitration cases and advises on procedural matters under SIAC and UNCITRAL rules. He brings wide-ranging experience in complex commercial disputes across sectors like shipping, energy, technology, and finance, with a focus on Asia and the Middle East. Prior to SIAC, he practiced at Colombo Law Alliance under the guidance of Dr. Asanga Gunavansa, President's Counsel, handling commercial, construction, and government-related matters. Also an attorney at law of the Supreme Court of Sri Lanka, he holds an LLB with honours from the University of London. We're delighted to have you here. So that is the introduction of our three expert panelists. I would like the three of you to join me up on stage. All right, so before we begin, I would like to share a few thoughts on artificial intelligence to set the background to today's conversation. I'm not going to run this like a standard panel discussion because I think everybody here would like something lively and interesting, right? So when we take AI, it has several promising use cases, especially in alternative dispute resolution. I won't go into too much detail on this, but we can say drafting, document review, case management, transcribing hearings, and using analytics to spot trends as a basic idea. But its role, I believe, should be supportive. While I am an AI enthusiast, I would never say use it in everything, right? Not substitutive either. Think of AI as an assistant, streamlining the work that you do. That said, recent court cases involving AI-generated fictitious citations are a clear warning that our professional duties, especially that of due diligence, remain unchanged regardless of the tools we use. With that as our starting point, I would like to direct the first opening question to all three panelists. In a minute or less, please share your thoughts. Could AI ever serve as a decision maker in arbitration? If yes, why? If no, why not?
For me, definitely not. Because my answer is definitely no. Because in decision making, there should be that human element. And therefore, AI is only a tool to help us, but not to make decisions.
All right.
You can get the assistance of AI, but decision maker must be natural person. This cannot be computer arbitrator or computer judge.
I don't think my answer differs to my fellow panelists. I think at the end of the day, any decision that you make has to have a human touch or an element, but getting the assistance of AI is something that we're in a generation that we're not going to see go away anytime soon.
All right, so I think across the board, the idea is the same. Use it as an assistant, but not to replace you. But I asked ChatGPT this question, right? For those of you who do not know what ChatGPT is, it's a large language model. It's like the thing that we define AI by nowadays. So I asked ChatGPT this question, and ChatGPT said, yes. ChatGPT said, yes, I can act as a decision maker. So we're definitely having a bit of a dialogue to look into today. Right, so my first question is going to be directed to Professor. How is AI reshaping evidence gathering in arbitration, particularly in areas like doc analysis, e-discovery, pattern recognition? Could you please explain this using maybe an example to illustrate if you have one?
Okay. Definitely AI is reshaping evidence gathering because you have document analysis, e-discovery, and pattern recognition. So if you look at all that, especially I am relating my case studies to construction. You see, in construction, we have so much. There are sometimes 40,000 documents, and sometimes it's not humanly possible for us to go through it. So AI is a tool that we can use to identify all this document analysis, e-discovery, and also pattern recognition. So if you look at document analysis, it is including analyzing large data sets, including emails, images, videos, social media, all that kind of thing. Then automatically extracting information from thousands or millions of documents and identifying relevant clauses and detect inconsistencies. Sometimes a human mind or human person will not be able to identify. The other one is AI systems can compare multiple versions of contracts, highlighting even subtle changes in language, tone, or risk exposure. So that is what AI does in document analysis. If you look at e-discovery, it is all AI scan massive volumes of digital data. Emails, messages, cloud documents, databases. And also it uses predictive coding, which is to rank documents by relevance based on sample tagging. And also can detect privileged, confidential, or duplicated content also. So AI is a tool. AI helps the lawyers, young lawyers, and even construction personnel to do this kind of thing. Document analysis, e-discovery, and of course, pattern recognition. Now, pattern recognition is okay, but again, once you make a decision, it's something else. Because for pattern discussion, you have identified anomalies, trends, and relationships in large data sets. In fraud or construction cases, AI can reveal suspicious payment patterns or progress in irregularities. Also supports forensic analysis and financial records and time logs. And impact uncovered hidden patterns that human review may miss. Just to give you an example, let me just take this. I like to give two examples. One is, with millions of global transactions daily, Alibaba faced, I know everybody knows Alibaba. Alibaba faced a large surge of low value, high volume disputes related to non-delivery, product mismatch, and return and refund issues. So what did Alibaba do? Alibaba had a traditional human-based resolution was slow and costly. So what they did was introduce a smart court or AI-led arbitration platform. That is one of the examples of Alibaba. But I'm closing much more in terms of construction. Now, for example, in construction, just give me 1 minute. This was a case study in multinational contractor versus government employer in 21-23. A tool used was a luminance and custom natural language process that was used. The problem was a $400 million infrastructure project governed by FIDIC Red Book contract faced prolonged delays, and the contractor filed an extension of time, or it's called EOT, and a prolongation cost claim with over 40,000 project documents, and which was involved. AI was used to manage and analyze the volumes of data. So this is one of the most important things for construction arbitration is, because I don't think many lawyers are into construction arbitration, and other than very few lawyers that I know. But it's very important for the construction lawyers also to know what construction arbitration is all about, because there's a number of documents, emails, AI, when I say AI, it's not artificial intelligence, but it is various documents that are related to changes, scope changes and things like that. So like that, there are so many documents and programs that has to be managed. So AI helps in that aspect, but not in actual decision making. Okay, thank you.
For sure. So I think the gist of what Professor was saying is that there is definitely great use of AI as a tool, but it should not substitute your work as a decision maker, as an arbitrator. You need to use it to assist your work and make it easier. And on what Professor said, Don, like if you have 40,000, 100,000 documents, you're going to, as a human being, you're prone to make a mistake along the way. Whereas a machine is something that's not going to take breaks, it's not going to get tired, it's able to process at a certain rate for however many hours you want, right? And there are basic tools, like for instance, I don't know how many people in the audience have used, there's a tool called Notebook LM. This is a very basic tool. Even the free version you can try using. If you have like a 1,000-page document that you want to, go through very quickly and get a summary, you just need to upload it and it will tag everything for you. It's very, very easy for you to learn things of materials which are large in size with the involvement of AI. So now you can see how, even in terms of what the professor said, there is a definite use there, right? So moving on, so there have been quite a few changes to guidelines, across different organizations. So if you look at the Silicon Valley Arbitration and Mediation Center in 2024 released some responsible AI use guidelines in arbitration. CIARB in 2025, VIAC in 2025, AAA-ICDR in the US again 2025. While these are all a positive step, they remain broad in scope, offering general principles rather than detailed rules. And a key common principle that we're seeing is that arbitrators must not delegate decision making. Okay, I think we'll come to that with you, Nusreen, a bit. So with that in mind, a quick question again to all three before I move specifically to Dr. Abhiratna. One or more can reply. As AI tools become more integrated into arbitration processes, what procedural safeguards should be in place, in your opinion? And are there any examples or best practices you've come across in this area already?
And thank you. Already this matter, what your question is before US Federal Court and La Paglia versus Well Corporation case. In that case, they look into the Silicon Valley Arbitration and Mediation Center guidelines and Chartered Institute of Arbitrators guidelines. The complaint was they trusted the arbitrator to give the decision. When the arbitrator uses artificial intelligence and give the award, that means he has delegated his power to another machine or whatever. That is not the expectation of the parties. So this is where there's one party challenge. Now there are pros and cons there, now they are debating, so that's why still that we didn't get the final decision from this judgment. As we are living in the transit period, let's see what is the judgment that they are. That depends on the intention, especially the party autonomy involved in that. There, what we can say is, before the arbitrator use artificial intelligence, it's a duty of the arbitrator to inform parties that he is using AI. This is the most important. Without informing that, if we use AI and if we trust AI, or he delivers the arbitral award purely based on AI, then one part, other party, defeat can challenge. The loser can challenge. Defeated party can go to courts and challenge the decision of the arbitrator. Then here, I wish to draw all of your attention. Here we are talking about artificial intelligence. We must not mix this artificial intelligence with big data. Now we are using computers and network compared to 1990s computers, today's computers, efficiency-wise, very efficient computers and devices we have today. And we are using the internet. The world has developed networks as well. This is not artificial intelligence. Artificial intelligence means that particular device behave like human brains, neuron cells. After training the tool, device, this example is robot. This particular device act as human. They take their own independent decision. Sometimes without getting the command from the human. If the human control that particular device, then you have to draw a line. It is very difficult. Whether it comes under AI or big data. Big data means 5 V's are involved in that. Because considering the efficiency of computers today, volume is very high, velocity is very high, veracity is very high, the ultimately value is also very high. This is not artificial intelligence. So without mixing, we have to carefully understand the situation. There is no harm to use big data to come to decision. You can use computer and database. When you apply AI only, these restrictions are there, especially what we discussed, Silicon Valley arbitration guidelines.
Thank you, Doctor.
Tanuki, if I may, I think something that we all know is the cornerstone of international arbitration or arbitration is confidentiality. The disclosure obligation should be there, but having said that, you also need to check the risk or run the risk of awards being set aside as a result of AI making that decision. Now, if you look at institutional rules, you'll see that the award shall be made by his or her, makes reference to a human that needs to make that decision. Now, even if you look at the New York Convention, it implies that someone who is a human that needs to make that decision. Now, the issue with AI is it's just as good as the data that is included. Now, as a result of that, you'll see biases by the AI itself. You'll have certain biases based on the arbitrators, the information that has been put into the system itself. So there could be instances where certain information is not put in, so you'll get a decision that is favorable to you. Or it just, and like Doctor mentioned, is that there could be instances where the AI cannot say no, so it will give you information that is not true, and you run the risk of an award being set aside. So something that we look at at an institution that we do is we run these awards. We cross-check them manually right now with the case papers to see if there's any reference to a case the tribunal is making that is not in the case papers, or any citation that is not there. So it's quite difficult to see an AI making a decision at this point that will not be challenged in court.
Yes, certainly, and that there is that risk of AI hallucinating and telling things that is not there and saying it very confidently as well, because we've seen time and time again lawyers in foreign jurisdictions citing cases which have not been there. They go back and they ask, say ChatGPT or Claude or whatever, they would ask, is this real? Is this there? And ChatGPT or Claude would reply back affirmatively and very confidently, yes, I believe this is there. Yes, I know this is there. This is in existence. So we definitely run that risk. And so it is ultimately the responsibility of the professional who is using such a tool to engage with it diligently and to cross-check everything you're doing. You cannot delegate your responsibility at any point to a system. I don't think that's something we can do at any point in the near future, or hopefully never, right? All right, so I'm going to quickly move to the next question. This is directed to Dr. Abiratna. As the panel's leading expert on ICT law, I'd like to direct a more technical question your way. In light of ongoing developments around data protection laws, both in Sri Lanka and globally, what risk does AI pose to confidentiality and cybersecurity in arbitration contexts, and how do you think these risks should be managed?
The best example is that at the moment, European Union, they have already introduced AI Act, especially to deal with collecting of personal data. In Sri Lanka, we have drafted Personal Data Protection Act number 9 of 2022 based on 7 principles adopted by GDPR, General Data Protection Regulation in European Union. We are still struggling to implement these rules. But European Union countries, they have gone a couple of steps ahead. They introduced this AI Act. One example is, under AI Act, there is a mandatory provision for data collectors. It's a duty of the data collector to inform data subjects and inform them how they are going to collect personal data of the people. If they say they use artificial intelligence to collect personal data, that is up to the data subject to take the risk. After giving this information, if the data subject give his or her personal data to data collector, then data collector has no responsibility. It is up to the data subject. So this is how, even in the United States, the White House, they introduce some policies. Policies are almost same like AI regulations in European countries. In future, there will be serious issues with the AI as far as personal data protection is concerned. Briefly, if I say 7 principles, there must be transparency when you collect personal data of a person. Then you can't collect personal data more than the requirement. If the data collector collects that, it's a duty of the data collector to return them. After collecting them, it's a duty of the data collector to give maximum security. Then if there's a contract, when the contract is over, then it's the duty of the data collector to hand over data. And accountability must be there. So now you can adjust this with AI and see whether we can really follow these 7 principles.
And Doctor, would you be able to comment a bit on right to deletion? Okay, we have a right to erasure, to delete your data. I as a data subject can request that you delete this data. And there's a significant issue there because once you feed some information into an AI system or tool, you cannot get it to unlearn this. How would we manage that particular data subject's right?
So that is alarm signal you get under AI Act. When you, after informing that, they use AI tools to collect personal data, that is up to the data subject to decide to give data or not. As you said, even no need to think about AI, even the normal computers. When we insert some data, some computers are there, they reproduce. Sometimes maybe backup copies. Or sometimes a computer through network, they send to various towers. These towers are not only in Sri Lanka or any particular country. In cyberspace, there are no territorial jurisdictions. So these are the practical issues.
All right, so we've got an understanding, a basic understanding. We can talk about this for a very long time when it comes to cybersecurity and data protection risks, but I hope you understand that this is not a conversation that we can stop having anytime soon. This is something that's going to keep moving and evolving. It's like a baby that has now reached a certain stage and it will just keep getting bigger and bigger. And unlike human beings, we don't know the extent to which we can control it, and at which point we are going to lose control. So there's this thing we call AI singularity, a point at which AI becomes something which no longer falls within the control of human beings, and neither will we understand how it is operating to be able to control it. So let's hope we never get there. I like painting the doomsday scenario all the time, but that's only because it should encourage us to think more along the lines of these risks and prepare ourselves for the future that we are heading towards. Again, a question to all three, maybe one or two of you can answer. Looking ahead, do you think it's realistic to expect that AI models such as LLMs or large language models trained on extensive collections of arbitral awards and practices could one day evolve into a super arbitrator capable of independently reasoning and adjudicating disputes by combining the best practices from around the world? Do you see a future like that? Why or why not?
I think you see a future in that because I saw in one of the case studies, you are profiling an arbitrator. You see, to choose an arbitrator, you have profiled depending on the various documentation given. So it's like trying to become a super arbitrator. See, so you can, I think there is a possibility of that. I'm not sure how that is going to be legislatively looked at.
True. Any other points?
I wish to add something. What is the expectation of the parties? Now take example, do you need neurologist or health? You expect justice or judge? So that depend on the requirement of the parties. Sometimes parties may feel that it's better to get the decision through software. Sometimes, in the meantime, some parties may think that no, there must be human touch. So that depends on the expectation of the party.
Do you think, I'm going to direct this question at Mr. Hussain, do you think that, the thing about technology is that it makes things very cost effective and it becomes easy to access after a point. So let's say this super arbitrator model becomes so cost effective that now we do not need SIAC, we do not need any of these centers. Maybe we need SIAC, but maybe 1 or 2 people just to administer this particular super arbitrator. Do you think people will go for it? Or do you think that people would still exercise caution and decide to have human involvement, human in the loop, or something like that?
I mean, it's a tricky place to be in because for institutions itself, we understand how important AI is. And we are trying to adapt, move along with the world. But you see certain processes that can be fastened with AI. For an example, a part of the award, the procedural history part of the award could be drafted by AI. But the decision making, I think, would still be with a physical human as opposed to a supercomputer. The reasons I say this is because, let's say, in a complex dispute, a board decision is made by the directors, and the reasons for that is based on various factors. The AI model might not be able to pick up that element as to why was this urgent, why was this decision made, what were the other policy considerations that they had to take. I think with time you never know, but right now it's black and white for AI. It will tell you whether based on the factors before me, this is what I decide, but doesn't take into the human element of decision making. Even for a construction contract as to why you would not do X amount of work and why it delayed damages for this issue, or whether something was on the critical path, is something that is a human decision that is made, so you're getting AI to make that decision.
Yeah. So those nuances are not always taken into account, and that's the problem. Professor, you want to add something?
No, not really. I was only thinking, what is Sri Lanka doing about AI? I can see very eminent people here. We are in the verge of starting AI, and do we have any legislations or anything like that? Because I think this is the best forum to discuss that. I'm not sure. Yeah. Anyway,
maybe that's a question we can direct at the audience in a bit.
Yes.
It's a valid question. And it's a question that people keep asking. Do we need an AI Act as well? Or do we need just some policy guidance on the use of artificial intelligence? That's something to definitely think about.
Now, for example, we don't allow students use ChatGPT in the university when they're writing their research and everything. So that is taboo, right? Where ChatGPT is part of AI, where it collects all kinds of data and they put it out, and sometimes they're not correct. But in reality, ChatGPT is part of AI in terms of collecting data, even in these particular projects, you see. So I personally think there should be some legislation brought by the legal profession, because we are on the verge of starting. Other countries are already, for China, all these people have gone beyond that, but we are still starting. So I think all these young lawyers who are starting here should be able to have some legislation that they can be guided by in terms of using AI.
Yeah, for sure. That's definitely food for thought, something that has come up in many conversations, I believe, and something that we need to think about, for sure. Yes. My next question is to Mr. Hussain. Could you tell us about how AI is being integrated into institutional arbitration, particularly in the context of SIAC, and what procedural innovations are being introduced to reflect or accommodate the use of AI, if any?
Thank you, Dhanuki. I think first and foremost, I think AI is like a disruptive intern that you never hired but has come to stay. Changing processes in the system, and you need to adapt. But I think in seriousness, it's also a challenge and an opportunity. I think the challenge is as institutions, we are masters of process. We need to balance that with reliability, and we also need to, with expeditiousness is something that we have at the back of our mind. So the question, like you said, is would people prefer AI because it's faster, or would they prefer something else, or with the human touch where it's much slow but you'll get a more accurate decision, I guess. As an institution, the question that we ask ourselves is how are we adapting? I think we have identified 4 areas that we're working on. The first, like I said before, is confidentiality and data security. So in the new 2025 SIAC rules, we have included a rule there to ensure that parties are mindful of their security obligations in terms of the data that they give to the tribunal, and that is within the arbitration itself. That is the first thing that we've introduced in terms of the rules. But in terms of case management itself, I think the first thing is efficient timelines in terms of sending letters out, especially on extension requests that come in because it's manually processed. So that is something that we are looking at. And in terms of financial management of the cases, because what we do is we track on our internal records as to whether the parties have paid their deposits, whether arbitrators have been paid. So I think these can all be assisted by AI. The second thing I would say is appointment of arbitrators. In terms of the SIAC rules I can speak for, is that the president of the SIAC court appoints the arbitrator. Even when their parties nominate, it's the president that finally makes that appointment. Let's say for an instant, the parties cannot agree on a nomination. What we do as counsel is we generate a list of names. Now, when generating this list of names, we need to see the qualifications in the arbitration agreements itself. Let's say the parties have said you need someone who has 10 years experience in the construction industry. That is a requirement that we look at. Then you look at the jurisdiction of the parties, the seat of arbitration, the governing law, the language of arbitration. All these are factors that we look at before we recommend to the president on appointment. So if this can be filtered out and given to us with a list, then we can proceed to inform the president, these are the names we have.
So unconsciously you are profiling the arbitrator, isn't it?
No, to an extent, because at the end of the day, in terms of the rules itself, if you have a party from Sri Lanka and a party from Singapore, there is no way we're going to appoint a Sri Lankan or a Singapore arbitrator. So you automatically would disqualify these persons who are sitting as panelists. The third one I would say is translation, because you have, the world is a global village, you have arbitrations in Chinese, translators coming, experts coming in different language. So getting them translated in real time is also very useful, and we see that in international arbitration. And the fourth thing is, I think, scrutiny of awards. That's the biggest challenge we have, is that we review every award that goes out through SIAC, and some other institutions do as well, is to double check that the arbitrator is making a decision based on the pleadings that the parties have filed before, and also whether there is a risk of the award being set aside because of public policy or even domestic requirements. So that is something that we can get AI to assist in, which will make the scrutiny process much faster, because let's say there's a quantum or expert report that I need to get a figure out. I'll have to read the expert report to get that figure just to cross-check on the award. So it's a cumbersome task. So I think with AI, we can definitely use that to assist us in being faster.
So I think based on what Mr. Hussain said, I will just add something there. So when you speak about kind of filtering out arbitrators, I think that's like we can look at it as a basic automation task, where you have a list and then you select, like check boxes of what you need, and then it will filter out names for you. Maybe something like that, which will not go to an extent of being biased in terms of selection. That's something you need to think about. And in terms of transcriptions and translations. I think one of those things that I would like to highlight at this point is also we are going to have an issue of bias because there's an AI language gap. Globally, you have like about, I think, close to 7,000 languages, but AI systems around the world, tools have only been trained for about 300 or 400 of those languages. So you can see the gap in terms of, language training. So it's not going to pick up on a significant chunk of nuances and, cultural aspects, things like that, which in many ways can become intrinsic to an arbitration process or any kind of legal process for that matter. So when it comes to translations, then we are going to have that issue of bias is what I thought I would like to add at that stage. So I think a lot of things we need to think of maybe starting at an automation level based on what you're saying, and then look at how we add certain features to that going along the way and with a lot of trial and error, I think, at this point. Thank you very much for that. So my last question before opening it up to the audience is, and this can be answered by either of you, what potential benefits does AI in arbitration offer for developing jurisdictions such as us? And in the context of Sri Lanka, how should these advancements be addressed through legal reform, regulatory guidelines, and/or institutional guidelines?
Some jurisdictions they claim as they are arbitration hub in the world. So considering that, of course, Sri Lanka will lose the business, especially in the international market. So this is a good option, especially that the popular area is online dispute resolution at the moment. So ODR, of course, there is no concept called arbitration hub. It's in cyberspace. So a country like Sri Lanka also can capture this market. Now, as far as language barriers are concerned, that we can apply artificial intelligence. Here, one thing we must remember, what do you expect from AI? Predictions or decision? This is the issue. The most of the AI tools are there to get predictions. Not AI can't, they can't go for decisions. So keeping that in mind, because the reason is, especially we must not forget the fact that there may be data bias and algorithm bias. Now, if the algorithm is wrong, sometimes it's very difficult to check. Because even if we ask to disclose that certain the algorithm, the pattern, and the mathematical summations, but sometimes the creator won't tell us because trade secrets are there. Yeah. It's subject to trade secret. So under these circumstances, how to get the confirmation that the particular algorithm is perfectly correct? So these are the issues we must keep in mind. There can be disadvantage. So my personal view is we can use these, so maybe software, AI means software. We can use this AI as assistance. This is why that's how I started my answer. You asked me the question, your first question. We must get the assistance of this AI and the technology, but we can't surrender the human rights to technology.
Yes, that's a very, very good thought to add. Thank you, Doctor.
If I may, I think it's not only to do with AI, I think it's the ecosystem itself. Is that you have a coherent system that is evolving with international arbitration. If you take, for an example, SIEC has introduced first institution to introduce ex parte emergency arbitration orders. So we introduced it in 2025 where a party can file a protective preliminary order where we'll issue it ex parte and within 12 hours the other party should be notified and then you'll have the emergency arbitrator appointed. And you also have streamlined procedure where you have an arbitration that concludes in 3 months. Now, if you're talking about AI and you're talking about expeditiousness, I think everything else also should be elevated, not just in terms of AI. So you need to come to a certain stage and then say, okay, AI is also important, but you also have to build the system around it that supports arbitration.
Yeah, I agree.
I too think that AI is only a tool. And if you're going to use it, some ethical guidelines should be there for us to use. So some of these policy decisions are in terms of making sure that all those aspects are looked into if you're going to use AI.
Yes, for sure. I mean, even if not in terms of legal reform, which could take some time, I think maybe you can start on an institutional level and look at a guideline for starters and take it from there. All right, so I would like to open the floor for questions, maybe 1 or 2 questions because we don't have a lot of time. Any questions from the audience to our panelists? Yeah, yes.
Hello. So first of all, very thankful to the
Hi.
panelists
Would you be able to, because this light is directly at the panelists, would you mind maybe coming this way so that they can see you as well?
All right.
Thank
This
you.
is all right? Just, I think, thankful to the panelists for a very promising discussion. But we were just wondering, are you able to hear?
It's not audible enough.
Okay, so thankful to the panelists for a very promising discussion. But we were just wondering whether, so as far as I understand from the discussion, we're looking at a possibility where AI does not replace arbitrators, but could potentially act as tribunal secretaries or assistants, right? So I'm just wondering whether, are we looking at a possibility where the AI algorithm can in fact, so basically who monitors the integrity of the algorithm? Because the AI algorithm, which would facilitate, the functioning of the AI as a tribunal secretary, can be compromised. So big tech can compromise the algorithm. Who is going to monitor that? What is your solution to that?
Your question is, who is going to monitor the algorithm that basically governs arbitration process? Is that what you're asking?
Yes. So from what I understand, you're looking at a future where AI replaces the role of a tribunal secretary or an assistant.
Yes, okay.
Right?
Yeah.
So who monitors the algorithm? Because we are looking at a future where the tribunal secretary, or AI in this instance, could basically filter certain cases that are positively impactful for a particular party and negative to another. So
Right.
who monitors that is a question.
Okay. I hope the panel, did the panel hear the question entirely? No. So her question is basically, we're looking at a future where AI would replace the role of a tribunal secretary. Then who monitors the role of the tribunal secretary who is now AI is the question.
If I may.
Yes.
I don't think it changes because if you take a tribunal secretary, the tribunal secretary does not make the decision. It is the arbitrator that makes the decision. So the arbitrator generally monitors the work of the tribunal secretary. Basically, what the tribunal secretary does is does the research, gives it to the tribunal, and the tribunal, yes, while relying on it, also has to do their own research because the tribunal secretary could get it wrong. Right? So then the question is whether the tribunal secretary is going to get replaced or the role of the tribunal secretary is not going to be there because you find certain arbitrators with disclosures being made. They use certain advanced AI tools where they put expert reports in and get summaries out of it. And so now the question is, this was a task that tribunal secretaries were tasked with. So the question is whether the tribunal secretary will be replaced as not to who is going to be monitoring. Because at the end of the day, the tribunal monitors what the tribunal secretary does anyway.
Right. I think the question was now if an individual tribunal secretary makes a mistake, you have some level of, let's say, supervisory role through the tribunal. Maybe I'm not too clear. So, but I'm asking of a situation where the entire LLM is being compromised. You can say, Meta example or one of the big tech, firms could basically compromise the integrity of the algorithm to prefer certain decisions over others. So essentially now if you're looking at exit arbitration, there could be certain big tech firms coming and preferring or getting the algorithm to give preference to certain decisions over the others. And therefore doing that indirectly sort of influencing the decision of the tribunal on a mega scale is the question.
So essentially, she's talking about how do we deal with bias within the system and how do you monitor that kind of thing. Yeah, Doctor, would you like to try?
That's what earlier also I said, because you can use this AI not as a decision maker. Only you can get the assistant. The reason is, now when you write software for AI, only single software writer can't do it. The minimum 500 to maximum 5,000 software writers are involved in that. That is how you get AI software. Other issue is sometimes one software writer doesn't know what are the other areas that other software writers have done. Then there are serious issues arise when you come to individual responsibility of software. It is always go for this AI to get the assistance. Maybe the litigation, maybe arbitration or mediation or whatever it is. Through AI, you can get some services through this software.
Analysis and things like
Analysis,
that.
collecting some information, so likewise. So when you come to the decision making, keep in mind, sometimes there is no way to question about the algorithms. Algorithm bias is there, that's why I answered earlier. So keeping in that mind only that you can use this technology, otherwise all will be trouble. So party autonomy is very important. When you go for this AI-based arbitration or litigation, then parties must know what's going to happen. When the arbitrator or the judge use AI, and after informing these two parties, then parties will take that risk and go ahead. This is the situation at the moment.
Yeah. And I think, and just adding to that, I think because bias when it comes to algorithms are here to stay. There is no way for you to remove bias because society is inherently biased, and in some way or the other that is going to seep into whatever it is that you're using, right? So it's difficult to address that. And on top of that, you have this aspect of AI in itself being a black box. Sometimes there are significant aspects of it which you can't explain to anybody, right? So I think an arbitration center can make a decision whether or not they're going to incorporate an AI tool as a replacement or not. And I don't think they will, because people know the inherent risks. I think what you will do is you will use it for certain tasks with human supervision, human oversight. I think that is the way to go. I think that is the way to go even in terms of legal processes. So that's something, I think that is how I would kind of collate our responses and tell you.
The long process is there. Okay, now, take what is AI? First of all, AI, initially software will come out. So thereafter, using AI tools, you have to train. You have to train this software. It will take some time.
Yeah.
Through that AI tool, that will lenses, other equipments. Then AI will get the experience, looking at the environment, getting information. It's like kindergarten student. Even that school children and all of that, you can train them, you can teach them a different way. So then how to trust this AI training tools first? So how do we know what are the tools they use to train this particular software? So these are complicated issues.
For sure. All right. So I'm not sure why there are like very fancy lights that appeared on the roof, but I'm assuming it's to indicate to me that I need to stop. But just to summarize, I think we, in many ways, this panel came to a single understanding, which is that AI is a useful tool. It's a supportive intern at best, but it should never replace your professional duties, your mind, your sense of diligence. I think that is basically the crux of the matter, and I think that applies across the board. I think that is the general view that everyone had. Thank you very much to everybody for being a part of this conversation. I know this is a topic that you can keep talking about for days, I guess. And I hope you have some interesting takeaways to take home with you. Thank you very much. I really enjoyed sharing the stage with you.
Ladies and gentlemen, now to award the tokens of appreciation for our respected panelists and the moderator for taking the time to remain with us throughout today's program and for also sharing extremely valuable insights on AI and arbitration, which I noticed that a lot of the participants were taking note of. To award the tokens of appreciation, I would like to invite the Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, Attorney at Law, up on stage. First and foremost, we begin with Professor Chitra Vedikara. Professor. Ladies and gentlemen, could we have a round of applause? Thank you, Professor. Up next, Dr. Sunil Aberatna. Mr. Nusri Hussain. And the moderator, Ms. Thanuki Gursingha, Attorney at Law. Thank you very much for joining with us. Ladies and gentlemen, we now arrive at a defining moment of this ceremony. With great reverence, we invite to the lectern our chief guest, Her Ladyship Murthu Fernando, President's Council, the Chief Justice of the Democratic Socialist Republic of Sri Lanka. A jurist of impeccable distinction, Her Ladyship's presence here tonight is a testament to the importance of nurturing young legal minds and elevating the future of international arbitration in Sri Lanka. Please join me in welcoming Her Ladyship to address us.
Yeah, light is a little too bright. Good evening to every one of you who are gathered here today at the closing ceremony of the Victors Moot 2025. May I begin by extending my humble gratitude to the Moot Society of Sri Lanka Law College, its officers, and the Principal Law College for your kind invitation to me to grace this occasion as its chief guest. I accepted this invitation with joy and happiness, since there is a special place in my heart for mooting. Moots today, and Victor's Moot in particular, are a far cry of the moots we had as law students. In reminiscing, I first took part in a moot court organized, or I can't even use the word organized, put together by our industrial law lecturer, Mr. Gomin Dayasri, as part of our study course in employment law or industrial law 43 years back at Law College. The venue was the lecture hall, being the main hall at Law College. Lecturer's desk was the bench, and we sat on chairs like a school debating team. Nevertheless, it was a very successful endeavor. And speaking for myself, it would have been a thrust that I received towards my future, my legal career, the pinnacle from which I will gracefully retire in a few days' time. At this moment, let me digress a little, and as the chairperson of the Council of Legal Education, acknowledge the kind generosity of Mr. Kanageeswaran and offer my sincere thanks to Mr. Kanageeswaran for your wonderful gesture in giving the Law College the much-needed state-of-the-art moot court with all its amenities. By such wonderful act, you have given the opportunity to law students to hone their skills and talent. And on behalf of the law student population, please accept our heartfelt thanks. Coming back to the victors' moot, the first international commercial arbitration moot competition in Sri Lanka is a platform for arbitration enthusiasts from the region as well as globally to promote arbitration as a preferred mode of dispute resolution. Having been a state officer representing numerous government departments and state corporations and state entities in court, and now a judge administering justice, I have seen the hyper-competitiveness of counsel, their relentless drive to win, sometimes at the cost of their own health and reputation. This fear of losing, win at any cost, sometimes even not following the best ethical practices, have tarnished the legal profession. In such a scenario, resorting to arbitration or alternative dispute resolution is much desired. You achieve the same object, dispute resolution. You are less tense, less stress. Win at any cost is not in the agenda. You strive to achieve a win-win solution. The final outcome, a happy and a contented legal professional and a litigant with a smile on his face for obtaining what he desired. In this context, I'm a firm believer in dispute resolution in a less formal backdrop, especially in matters relating to international commerce, but with the same sense of finality. I cannot overstate the importance of globalization, which is rapidly encroaching on all strands of our lives as we speak. International commercial arbitration has emerged as the most viable branch of dispute resolution in cross-border business affairs, predominantly owing to the fact that it provides parties with an impartial and legally binding means of resolving conflicts spanning multiple regions. It is almost inevitable that parties or companies dealing with any kind of international commerce must ensure they have access and they have a viable background knowledge to understand the positivism of arbitration. Such in-depth, I'm sure, will ensure smooth business operations as they look to enhance their business and promote their products within the global village. So where can they get the human resources with this expertise? Lawyers who have a passion for alternative dispute resolution. Does our legal academia provide this experience? Have our legal education overlooked this fact? Is it a lacuna in our legal education? Our country, our people are used to adversarial litigation. They love hostile rivalry. They are satisfied when one party becomes speechless or nonplussed in court. Law students are no exception. Media depicts such adversarial attitude as the norm. The louder you are, the happier your client. Unfortunately, importance of alternate dispute resolution, arbitration in particular, has not been focused much in our education system. This, I believe, is a lacuna which has come into focus with the changing paradigms of the modern world. And Victor's Moot is a very important impetus which fills this lacuna overlooked by our legal education, to train young minds to be analytical, flexible, and decisive, and not to go for the kill, as the saying goes. In this context, I congratulate the Sri Lanka Law College and the Moot Society for the initiative begun 8 years ago and still continuing in the same spirit and with much enthusiasm. The exposure to Victor's Moot gives students here and overseas is tremendous. Not only their skills in advocacy is enhanced, their quest for knowledge, research, analysis, writing is also realized. Flexibility in pursuing an intellectual discussion in a healthy environment is also achieved. I congratulate all students who participated in this competition from far and wide. Whether you won a commendation or not, what matters is you have taken a step into a very interesting branch of law, and I hope to see you cherish in your chosen field. Victor's Moot, as we are well accustomed to, is the shortened form for Herbert Victor Pereira Queen's Counsel Memorial International Moot Competition. In this time of age, what does H.V. Pereira, a QC of a bygone era, signify? Why was this moot named H.V. Pereira? My curiosity arose because of the name used, Victor's Moot. I did not ask anyone for an insight. I gave my own explanation. I hope I am not wrong. Queen's Counsel H.V. Pereira, a giant of the bar, a distinguished personality, learned in the law, who walked through the halls of Law College, is a person par excellence. His demeanor, his command of the legal knowledge, criminal law in particular, his ability to argue cases on the first principles made him a peerless advocate. His arguments in the famous breast girdle case is something all law students should be familiar with. His humility is well known. H.V. Pereira was invited to the inner bar by the then Chief Justice Sidney Abraham while he was acting as the Governor General of the island. On his swearing in as a Queen's Counsel, Mr. Abraham uttered the famous words, "The honor has never been more deservedly granted, and you have enhanced the distinction which has been conferred on so very many distinguished sons of this island." I believe naming of the International Commercial Arbitration Moot Competition by a legal luminary of H.V. Pereira QC's caliber adds color and flavor to the importance of this moot competition. My dear participants, students, recipients of awards and accolades, I could only say, strive to live up to the benchmark of H.V. Pereira. When pursuing your legal career, you should have the command of the legal knowledge, ability to answer on first principles, never mislead or deceive court or any questions of law or fact. Be fair, be frank, be honest, be eloquent, have a razor-sharp mind, and above all, earn the confidence of the bench. And with those words of encouragement, borrowed from the lips of a former Chief Justice, Sidney Abraham, I thank you for organizing this committee. I thank you to the organizing committee of the 8th Victor's Moot for a successful completion of another moot. May you go strength to strength, and keep the name of Sri Lanka Law College flying high as always. Thank you, and wish you a good evening.
I kindly request my lady to remain on stage. As a token of our deepest gratitude and respect, we now present mementos of appreciation to the chief guest and our guests of honor. We invite the principal of Sri Lanka Law College, Mr. Prasantalal the Alves President's Council, to kindly step forward for the presentation of the tokens. The chief guest, Her Ladyship Murdu Fernando, President's Council. Thank my lady. Kindly remain on stage, sir. The guest of honor, the Solicitor General of Sri Lanka, Mr. Viraj Dayaratne, President's Council. Thank you, sir. Guest of honor, Dr. K. Kanagiswaran, President's Council. Thank you, sir. Ladies and gentlemen, let me now direct your attention towards the screen as we walk down the memory lane and look at what Victor's Moot 2025 was all about. Few understand the art of advocacy quite like the bench. We now invite our esteemed final round arbitrators to share their reflections on the grand finale, the legal acumen, the preparation, the arguments, and the moments that defined the 8th Victor's Moot. On behalf of the final round judges, I invite Dr. Asanka Gunavansa, President's Council, to present the review of the final round.
Your Ladyship, the Chief Justice, the Principal of Law College, the other senior colleagues, and all the participants. Sorry, I wasn't ready to make any speech. I was under the impression my colleague Chandaka was going to speak. But in any event, especially for the participants, you all have had a few long weeks of preparation, and then the preliminary rounds, the semi-finals and the finals. A lot of hard work has gone into it, so I'm not going to prolong your suffering, but let me just share a few words, and whatever I say comes from, based on a discussion that I have had with the other two colleagues of mine, Mr. Chanaka De Silva, President's Council, and Mr. Chandaka Jayasthira, President's Council, who sat together with me as the three arbitrators for the finals. We were all very impressed with what we saw from the participants in the finals. The way they responded to the questions that were put to them by the tribunal was outstanding, I thought. And what was showcased by the participants was not only that they have had a lot of hard work in preparing, but they also have gained a lot of substantive knowledge, both on the procedural aspects as well as the key legal issues that were part and parcel of the submissions that they had prepared, and not only in written form, but also the oral submissions that they made during the finals. So I think all of you have a great future, and it's very good to see that students like you taking a very keen interest in alternative dispute resolution. And I think, like one of the speakers said earlier, this is the way forward, at least for when we consider commercial and contractual disputes. There was a time back in the day when we were in law school, subjects like ADR was not even taught. And most of us, try to learn about ADR after we took course and start practicing. And most of us are self-learned, by reading books and articles and so on. But now you, on the other hand, have an opportunity of not only being provided a proper education, but also having platforms like Moot courts in which you can showcase your skills. So that's the way to go forward. Very well done for all the participants. And my congratulations to the winners, who will be teams as well as individual winners who will be named later. So thank you very much, and take care.
Thank you very much, sir. I kindly request you to remain on stage. Ladies and gentlemen, in appreciation of the services and the support extended by our final round judges, I invite the President of the Moot Society of Sri Lanka Law College, Mr. Tisuru Hettiarachchi, to present the tokens of appreciation to the final round arbitrators. Ladies and gentlemen, Dr. Asanga Gunawansa, President's Counsel. Thank you, sir. Mr. Chandaka Jayasundara, President's Counsel. Thank you, sir. And in absentia, we must recognize Mr. Chanaka De Silva, President's Counsel, who is also part of the arbitral panel. Furthermore, ladies and gentlemen, now we take this opportunity to recognize one of the key supporters of the 8th Victors Moot, that is the Singapore International Arbitration Center, or SIAC. In recognition of this, to present or to accept the token of appreciation on behalf of SIAC, I invite Mr. Nusri Hussain. Thank you very much. And now, the hour of celebration is upon us. Over the past few days, the rounds, the teams have argued with brilliance, drafted with precision, and spoken with courage. Let us now honor the exceptional among the excellent. And to start things off, let us first recognize the teams that took part in the 8th edition of the Victors Moot. We will first recognize the teams that are joining with us online virtually, as we have quite a sizable number of foreign teams that are taking part. And as a slight disclaimer to all the teams that are joining with us online, I do hope that since there are certain cultural differences and linguistic differences, there might be slight mispronunciations of your names despite us double-checking it. And if that may be the case, please do accept our most sincere apologies. Ladies and gentlemen, the Singapore Management University, represented by Ms. Chang Sang-ying, Ms. Isaac Yang, Mr. Darius Wan, and Mr. Jobs Tang. The National University of Singapore, represented by Mr. Glenn Teo, Mr. Myron Sivalingam, and Ms. Tong Siu En. OP Jindal Global University, represented by Mr. Aniruddha Satish, Ms. Arundhati De Cruz, Ms. Adya Yalamanchi, and Ms. Vagisha Gupta. The NASA University of Law, represented by Mr. Aryan Kapoor, Mr. Vaibhav Gautam, Mr. Sajjad Momin, and Ms. Reena Shah. The University of Nairobi, represented by Mr. Vanislaus Roy Obre, Ms. Angela Muru, Ms. Ann Mwanda, and Mrs. Rose Crystal. The Maharashtra National Law University of Nagpur, represented by Ms. Ayoli Shukla, Ms. Alifia Olia, Mr. Manthan Patel, and Ms. Anubhuti Tiwari. The West Bengal National University of Judicial Sciences, represented by Ms. Sayonika Dar and Ms. Mansi Gupta. The Gujarat National Law University, represented by Mr. Yogesh R.S., Mr. Subhojit Mazumdar, Mr. Prince Raj, and Mr. Dhruv Harjani. The School of Law Christ, Bangalore, represented by Mr. Karthik Tripathi, Mr. Vaibhav Raj, Ms. Manchi Chaturvedi, and Ms. Simran Agarwal. The University of Aberdeen, represented by Mr. Alisina Hassani and Ms. Beth Doherty. Africa Nazarene University, represented by Ms. Zarina Sileti, Ms. Yvonne Wainona, Ms. Felista Yugotsa, and Ms. Serene Kimani. Dr. Ram Manohar Lohia National Law University, represented by Mr. Ayanshar Agarwal, Ms. Johanlagan Harshini, Ms. Elnaz Said, and Ms. Vaidehi Singh. The Institute of Law, Nirma University, represented by Ms. Anshita Khanjani, Ms. Shelly Jain, Mr. Arya Tyagi, and Ms. Samriddhi Singh. And joining with us online is Apit Candy, represented by Ms. Shaima Reyes, Ms. Vandana Jayavardhana, Ms. Rithmi Vijayveera, and Ms. Sanduni Ponveera. The Tamil Nadu Dr. Ambedkar Law University School of Excellence in Law, Chennai, represented by Mr. Kamlesh Nath, Mrs. Smriti Anil Kumar, Mr. Sahitya Nirupan, and Mrs. Monica. And now to acknowledge the teams that did make the time to join with us in person. Starting off with the Faculty of Law, University of Colombo. Before that, I would like to kindly invite up on stage The Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, Attorney at Law, to give away the participation certificates for the participants who joined with us. The Faculty of Law, University of Colombo, represented by Ms. Timanti Jayasurya, Ms. Fatima Hafsa Hussain, Ms. Muhammad Rushda, and Ms. Muhammad Risla. We invite you to come and collect your certificates. Faculty of Law, University of Colombo, Ms. Hafsa Hussain, Ms. Muhammad Rushda, and Ms. Muhammad Risla, and Ms. Timanti Jayasurya. Next up, we have the General Sir John Kotharaval at Defence University, represented by Mr. Nimsara Rupasinghe, Mr. Keshan Anthony, Ms. Sisuri Jayawardena, and Ms. Shamudi Bopage. We invite you to come and collect your certificates. Ladies and gentlemen, the General Sir John Kotharaval at Defence University, represented by Mr. Nimsara Rupasinghe, Mr. Keshan Anthony, Ms. Sisuri Jayawardena, and Ms. Shamudi Bopage. And up next, we have the Royal Institute of Colombo, represented by Mr. Asala Rajapaksa, Mr. Reen Dharmadasa, Mr. Anik Abdin, and Ms. Tashia Jayawardena. Colombo, represented by Mr. Asala Rajapaksa, Mr. Reen Dharmadasa, Mr. Anik Abdin, and Ms. Tashia Jayawardena. Thank you very much. Up next, the University of Jaffna, represented by Ms. Piranitha Prathipan, Ms. Sukuni Veenavi, Ms. Tambagalla, and Mr. Venura Jayasankar. Proceeding on to the University of Peradeniya, represented by Mr. Amayuru Senadira, Ms. Hakima Nasir, and Ms. Udara Veerasinghe. Moving on to the Asia Pacific Institute of Information Technology, APIT Colombo, Mr. Avishka Artigala, Ms. Zeenat Mujib, Ms. Gayatri Manoharan, and Mr. Purna Nanayakara. by Mr. Avishka Atigala, Ms. Zeenat Mujib, Ms. Gayatri Manoharan, and Mr. Purna Nanayakara. Thank you very much, sir. Ladies and gentlemen, with that, we now move on to the special awards. For eloquence and persuasion beyond measure, the honorable mentions for the best oralist. To give away the awards, I would like to invite the principal of Sri Lanka Law College, Mr. Prasantalal Dialvis, President's Counsel. Honorable mentions, best oralist. Representing the Royal Institute of Colombo, Mr. Asala Rajapaksa. From the Royal Institute of Colombo for the honorable mention of Best Oralist. Second honorable mention, representing the Singapore Management University, Ms. Chung Sing. Representing O.P. Jindal Global University, Ms. Arundhati de Cruz. And ladies and gentlemen, the best oralist of the finals. Representing the Singapore Management University, Ms. Chang Ying. The runner-up of the best oralist, representing the University of Nairobi, Mr. Vanistal Aubrey. Thank you very much. Proceeding on, ladies and gentlemen, to the architects behind the written word, the teams whose memoranda stood out. Awarding the late Justice Dr. A.R.B. Amarasinghe Memorial Award for the Best Memorandum for Claimant Runner-Up. The plaque runner-up is the Royal Institute of Colombo, represented by Mr. Asala Rajapaksa, Mr. Reen Dharmadasa, Mr. Anik Abdi. I invite the guest of honor, Dr. K. Kanagiswaran, to present the award to the best memorandum for the claim. Ladies and gentlemen, the best memorandum for claimant runner-up, the plaque winners, Royal Institute of Colombo, represented by Mr. Asala Rajapaksa, Mr. Reen Dharmadasa, and Mr. Anik Abdi. and gentlemen, the best memorandum for claimant winner, plaque, the champion. The winner of the plaque for the best memorandum is Apit Kandi, represented by Ms. Shaima Rias, Ms. Vandana Jayavardhana, Ms. Rithmi Vijayveera, and Ms. Sanduni Ponveera. Proceeding on to the best memorandum for the respondent, the plaque runner-up. The runners-up of the best memorandum for respondent is the University of Colombo, represented by Ms. Simanti T.K. Jayasuriya, Ms. Fatima Hafsa Hussain, Ms. Rifkan Rushda, and Ms. Muhammad Ashraf Risla. The runner-up, Faculty of Law, University of Colombo, Ms. Simanti Jayasuriya, Ms. Hafsa Hussain, Ms. Rifkan Rushda, and Ms. Ashraf Risla. Thank you very much, sir. Ladies and gentlemen, the best memorandum for respondent, the winner. The winner for the best memorandum for respondent is the Maharashtra National Law University of Nagpur, represented by Ms. Ioli Shukla, Ms. Alifia Olia, Mr. Manthal Patel, and Ms. Anubhuti Tiwari. Congratulations to the Maharashtra National Law University for winning the best memorandum for respondent. Ladies and gentlemen, as we now move on to the plate round winner. Ladies and gentlemen, the winner of the plate round is the National University of Singapore, represented by Mr. Glenn Teo, Mr. Mayuran Sivalingan, and Ms. Tong Siu En. Before we proceed to the rest of the awarding, I would like to invite, to give away the award, the guest of honor, the Solicitor General of Sri Lanka, Mr. Viraj Dayaratne, President's Council, accompanied by the Principal of Sri Lanka Law College, Mr. Prasanthal De Alvis, President's Council. Ladies and gentlemen, could we have a round of applause for the semi-finalists of the 8th Victor's Moot. The semi-finalists, Royal Institute of Colombo, represented by Mr. Asala Rajapaksa, Mr. Reen Dharmadasa, Mr. Anik Abdin, and Ms. Tashia Jema. The semi-finalists, Royal Institute of Colombo, Mr. Asala Rajapaksa, Mr. Reen Dharmadasa, Mr. Anik Abdin, and Ms. Thashia Jema. The semi-finalists, Maharashtra National Law University of Nagpur, represented by Ms. Ioli Shukla, Ms. Alifia Olia, Mr. Manthan Patel, and Ms. Anubhuti Tiwari. Congratulations to the Maharashtra National Law University of Nagpur. Thank you very much, sir. I now invite the Chief Guest, the Chief Justice of the Democratic Socialist Republic of Sri Lanka, Her Ladyship Murthu Fernando, President's Council, accompanied by the Principal of Sri Lanka Law College, Mr. Prasantalal de Alves, President's Council, for the rest of the awarding segment. First and foremost, ladies and gentlemen, the best overall oralist. The best oralist of the 8th Victor's Moot, representing the Africa Nazarene University, Ms. Sarina Tsemutai Silete. Congratulations to Ms. Silete from the Africa Nazarene University for winning the best oralist. And now, ladies and gentlemen, proceeding to one of the two most awaited awards. The runner-up and the champion of the 8th Victor's Moot. Two teams competed in the finals. The Singapore Management University and Apit Kandy. Presenting to you the winners of the 8th Victor's Moot. Apit Kandy, on behalf of the team that is representing Ms. Shaima Reyes, Ms. Vandana Jayavira, Ms. Rithmi Vijayveera, Ms. Sanduni Ponveera, is the coach, Mr. Dylan Vijaysurya, accepting the award. I invite Mr. Vijaysurya on behalf of the team to collect the Champions Award. Ladies and gentlemen, presenting to you the champions of Victor's Moot 2025, Apit Kandy. A round of applause, ladies and gentlemen, to the winning team represented by Ms. Shaima Reyes, Ms. Vandana Jayavira, Ms. Rithmi Vijayveera, and Ms. Sanduni Ponveera, and the coach, Mr. Dylan Vijaysurya, accepting the award on behalf of the team. And ladies and gentlemen, presenting to you the runner-up of the 8th Victor's Moot, the Singapore Management University, represented by Ms. Chang Ging, Mr. Isaac Yang, Mr. Darius Wan, and Mr. Jabez Tang. The runners-up of Victor's Moot 2025, the Singapore Management University. Thank you very much, my lady. Thank you very much, sir. Ladies and gentlemen, victory belongs to many, the determination to all, and as such, we have now honored the victors of Victor's Moot. To close this celebration of law and legacy, we invite the dedicated leader of this year's organizing committee, Mr. Vinura Gamage, the chairperson of Victor's Moot 2025, to deliver the vote of thanks on behalf of the Victor's Moot organizing committee. Over to you, Mr. Vinura.
The 8th Victor's Moot was not a competition that took place overnight. It certainly wasn't a competition for the faint-hearted, because myself, the head committee, the junior committee, the senior committee who took charge of Victor's Moot 2024, our principal, our deputy principal, the administrative staff of Sri Lanka Law College were all part of the 8th Victor's Moot, coming to a successful completion at this very moment. However, it is not right to end the closing ceremony of the 8th Victor's Moot without thanking a few notable individuals who contributed immensely for the successful completion of this moot competition. Firstly, I would like to extend my deepest gratitude to our chief guest, Chief Justice of the Democratic Socialist Republic of Sri Lanka, Her Ladyship, Honorable Murudhu Fernando, President's Council. Dear Madam, thank you very much for taking your time and attending the 8th Victor's Moot closing ceremony. It means the world to the organizing committee and to the hard work of all the participants who took part from all across the world. I extend my deepest gratitude towards you, Madam. I would also like to extend my gratitude to the guest of honors. Firstly, to Solicitor General of the Democratic Socialist Republic of Sri Lanka, Honorable Viraj Dayaratna, President's Council. Dear Sir, thank you for taking your time off of your busy schedule and being a part of the closing ceremony of the 8th Victor's Moot. Of course, the guest of honor, Dr. K. Kanagiswaran, President's Council, without whom the 8th Victor's Moot would have probably never happened within the premises of Sri Lanka Law College. It is a great honor as students of the Sri Lanka Law College to host our very own international moot competition within our very own moot court. Thank you very much, Dr. K. Kanagiswaran, President's Council. I believe the admiration from the audience speaks for itself, for the admiration that the Moot Society has for you. Of course, the principal, the deputy principal of Sri Lanka Law College, Mr. Prasanta Laldi Alvis, President's Council, Mr. Shehan Pereira, Attorney at Law. I cannot count the times where either myself, our President Tisuru, or one of our committee members have approached you two during the last 6 to 7 months, requesting for a letter, requesting to something to be proofread, requesting for approval and whatnot. But regardless of our request, dear principals, you've always made sure that you've given us a helping hand and you've given us a helping ear at all times. For that, I believe myself, the senior committee, the junior committee, and even most of our alumni who is present here today are very grateful for the support that you have showed us. Dear Principal, dear Deputy Principal, thank you very much for the sincere support that you have shown to the Moot Society of Sri Lanka Law College. Thank you very much, sir. And next, I would like to extend my deepest gratitude to the arbitrators of the final round. Mr. Chanaka De Silva, President's Council, Mr. Chandaka Jayasundara, President's Council, Dr. Asanga Gunavansa, President's Council. Thank you very much for taking your time and being part of the 8th Victor's Moot. The final round, as the organizing committee, it was a treat for us. It was an enticing competition, and it certainly was more colorful with our eminent panel of arbitrators. Dear sir, dear arbitrators, thank you very much for being part of the final round of the Victor's Moot. I would also like to extend my sincere gratitude to our panelists of the day. The 8th Victor's Moot had the prestige of holding a panel discussion on artificial intelligence and arbitration. That is, of course, for my understanding, when our Secretary of the Moot Society suggested it to me, one of the most unique areas of expertise that is currently in arbitration. And for that to be possible, our panelists of Professor Chitra Vedikara, Dr. Sunil Abhayaratna, Mr. Nusri Hussain, coming all the way from Singapore to attend the closing ceremony of the 8th Victors Moot. Dear panelists, I would like to extend my sincere gratitude towards all of you. It was an enlightening discussion for the entirety of this audience, and I'm pretty sure that all the participants who joined online from across the world found it extremely enlightening, and they learned something valuable from the panel discussion. Thank you very much, dear panelists. I would also like to extend my gratitude towards our moderator, Ms. Tanuki Gunasinghe. Thank you very much, ma'am, for taking the time to moderate this amazing session. Thank you, dear panelists. Thank you, moderators. Next, I would like to extend my sincere gratitude to the Singapore International Arbitration Center. I believe it was the idea of our senior committee of USMA and Tisuru back in December 2024, where they suggested maybe we could use the help of Mr. Nusri Hussain in the hopes of making sure that SIAC takes part in the 8th Victors Moot. Tisuru USMA, I believe we were successful in doing that. Mr. Nusri Hussain, thank you very much, and please extend our sincere gratitude to all the officials at the Singapore International Arbitration Center and for the support provided by the SIAC organization towards the 8th Victors Moot. Next, I would like to extend my gratitude to a few key supporters of the Victors Moot throughout the years. Firstly, to former principal of Sri Lanka Law College, Mrs. Indira Samarasinghe, President's Counsel. It is an immense pride for me as the chairperson of the 8th Victors Moot to have invited you to the closing ceremony of the 8th Victors Moot. We're deeply thankful for your continuous support for Sri Lanka Law College even after your tenure as the principal of Sri Lanka Law College. Mrs. Indira Samarasinghe, we're extremely grateful for your presence here, and we thank you very much. Also, to Mr. Upul Jayasuriya, President's Counsel, dear sir, please accept our sincere gratitude towards you. Thank you very much for your support to the Victors Moot and for the Moot Society of Sri Lanka Law College. Also, I would like to extend my gratitude to Ms. Malina Amarasinghe, who is not present today, however, has been a continuous supporter of the Victors Moot in memory of her father, the late Justice A.R.B. Amarasinghe. Thank you, Ms. Malina Amarasinghe, for always supporting the Victors Moot. I would also like to extend my gratitude to Ms. Hemamali Amarasinghe, the Chief Executive Officer of the Institute for the Development of Commercial Law and Practice. Thank you, Ms. Hemamali Amarasinghe. You've been a continuous supporter of the Victors Moot, and we're extremely grateful for your support and for the fact that you are present with us at this closing ceremony. Next, the 8th Victors Moot would not be possible without our invaluable sponsors. To Tokyo Cement, Nitya Partners, FJ&G Deserum, ICLP, thank you very much for being part of the 8th Victors Moot. You have done a considerable contribution towards the future of the legal profession of Sri Lanka. And of course, the arbitrators of the 8th Victors Moot. This time, the 8th Victors Moot, in its history of the Victors Moot, had the most number of arbitrators taking part. We had over 70 arbitrators taking part over 22 rounds over 2 days of competition. That, ladies and gentlemen, is a first for the Moot Society of Sri Lanka Law College, and we're extremely grateful for the time and effort put by the arbitrators of the 8th Victors Moot. Of course, the 8th Victors Moot would never have been possible without our brilliant participants. It is a shame that we can't see you here at this stage, at this audience. However, do know that you are in our hearts, and we are extremely grateful for your participation, and we hope that we were able to deliver a wonderful mooting experience for all of you. Of course, I should also express my gratitude towards the swing team and the coach, Kavindu Jayawardena. Thank you for taking up this challenge in a short notice. I believe the hardships were extremely tough. However, the swing team delivered a great session throughout the 2 days, and I'm extremely grateful to the swing team and for the coach for his continuous support. Thank you, dear sir. And of course, again, there's so many people to thank for. I cannot forget the Moot Society alumni. To Ms. Daupadi Jayavira, Nimanga Sena Nayaka, Praveen Jayasundara, Saini Fernando, and all the past committee members. Thank you very much for your continuous support. I cannot express to you the times that we had to depend on our seniors and on our alumni. Thank you very much for always being there for us. I should also like to extend a special thank you to Mr. Kavidu Tennakon for all the support throughout the 8th Victors Moot since November 2024. Ever since our board got the Victors Moot Organizing Committee, Mr. Kavidu Tennakon was a vital part of the procedural matters. Of course, next, I would like to thank our compeer for the evening, Ruin. Thank you very much for the amazing comparing. I believe everyone in this audience had a great time with you as the comparer. The admiration from the audience speaks to the quality that you served with us. Of course, for the volunteer committee of the 8th Victors Moot, these were individuals who were not part of the organizing committee. However, through friendship mostly, came to support us during the last 2 days, during the last few months, and they were always there with us. And these are our friends at Sri Lanka Law College. Thank you very much, the volunteer committee of the Victors Moot. And finally, and of course not the least, the organizing committee of the 8th Victors Moot. The organizing committee of the 8th Victors Moot is predominantly 2 parts, the senior committee and the junior committee. But I believe there is so much effort that was put into the organization of this event. Towards the end of today, to be honest, there was no disparity between senior committee or junior committee. Everyone was knee-deep into organizing the Victors Moot, and your contribution is what everyone was able to experience today. So, towards the organizing committee, ladies and gentlemen, I would like to extend all of you to give a warm round of applause to the organizing committee of the 8th Victors Moot. And with that, ladies and gentlemen, I would like to end my speech. And one thing that our principal sir and the deputy principal sir has always imparted on us is that Law College is the cradle of legal education in Sri Lanka. Hopefully, more events like this from the Moot Society of Sri Lanka Law College would ensure that Sri Lanka Law College is the cradle of legal education in Sri Lanka. And also, it is on behalf of the Moot Society of Sri Lanka Law College, I can always assure you that Sri Lanka Law College will in fact remain as the cradle of legal education. Thank you very much, ladies and gentlemen. I hope you all had a wonderful evening.
Ladies and gentlemen, since Mr. Gamage was not able to thank himself, the driving force behind the 8th Victors Moot, Vinura Gamage, the chairperson, whose shoulders probably hurt from carrying the weight of the moot court competition. Ladies and gentlemen, with that, we now request you to rise as we conclude our ceremony with the national anthem of the Democratic Socialist Republic of Sri Lanka.
Sri Lanka Mata, Upper Sri Lanka, Namo, 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 Namo Mata. Sundara Siri Barini, Surandi Ati Sogamana Lanka. Dhanya Dhanaya Nekamal Palaguru Piri Jaya Bhumiya Ranya. Apahata Sapa Siri Sata Sadhana, Jivanaye Mata. Pilidanu Mena Apabhakti Puja, Namo Namo Mata. Upper Sri Lanka, Namo, 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 Namo Mata. Obave Apavidya, Obamaya Apasatya, Obave Apashanti, Apahada Tulabhanti, Oba Apa Aloke, Apagi Anuprani, Oba Apa Jivanave, Apa Muktiya Obave, Nava Jivana Denini, Nikina Apa Kubudu Karan Mata. Jnana Veera Vadava Minaragena Yanu Mena Jaya Mudikara. Ekramavaka Dedaru Kalabarina, Yamu Yamu Vinopama. Prema Vada Samaveda Durarala, Namo Namo Mata. Upper Sri Lanka, Namo, 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 Namo Mata.
This concludes the closing ceremony of the 8th Victors Moot. To every participant, judge, speaker, arbitrator, and supporter, thank you. To every aspiring law student out here, go forth, advocate with honor, and may the law forever be your compass. Good night.